Yes, Mr. Jones.
Lordship, I think I've kept you anticipating my submissions on Latter for quite long enough, so I'm going to move on to that part of the case.
Right.
Just to one final observation with regard to our Article 3 submissions. On that schedule as well, we did set out the current care provision note at paragraph or page 3 and outlined in bullet points the forms of support and assistance that were currently being given by PE in particular, and we just commend those to you as well. And what I hope you'll see from that is the breadth and nature of the support that's given, and the kind of extension of that support beyond the physical and practical and into the emotional. And perhaps most importantly is the element relating to reassurance and how that enables the appellant to manage the panic attacks, the traumas that lead to those behaviours that can, the exhibition of hair cutting and so forth. So I flagged that for your consideration. So turning to the issue of Latter, Lordship, the position of the Upper Tribunal with regard to the application of that provision was described in its determination, I think, from paragraphs 12 through to 15. The judgment of the tribunal is at page 58 of the core bundle.
Yes.
And essentially the analysis performed by the tribunal is focused upon three elements of the appellant's case. One is the paragraph 13 is the judge's summation of the issues as she understood them to be, indeed as they were articulated in the written argument of the parties. The second is the I think the way the case was. I do apologise. It's page 58 is the judgment of the Upper Tribunal, and the part we're looking at is page 60.
It's page 60. It starts at 58.
Thank you. Sorry, my fault.
Apologies. Page 60.
It's paragraph 12 to 15. You said.
Thank you.
So there's a reference to the issues described on the face of the first tier tribunal's determination, and you'll find those issues set out on page 101 of the core bundle, paragraph 9 of the first tier tribunal judgment. Then there's reference to the skeleton argument that was put in on the 21st of October 2022, I think. And then finally there's reference to Dr. Heke's report, the parts of it that were cited to the Upper Tribunal. And the conclusion of the Upper Tribunal at paragraph 15 is that there is nothing here or anywhere else in the report that identifies the importance of care being received from PE in particular, or continuity of care more broadly. There is no discussion of the likely impact of any change of carers except with regard to this specific issue of receiving intimate care. And then preceding that, with regard to the skeleton argument, I think they'd said, paragraph 13, I apologise for moving around like this, the last sentence at the hearing before us, Ms. Fitzsimmons referred to the reference to the skeleton to appellant's unusual level of dependency on PE, but
I'm now lost. Which paragraph?
I beg your pardon. It's paragraph 13, top of page 61,
Oh, right.
last sentence.
Yeah.
So the sum of it is essentially that on the analysis of how the issues were contrived on or described in the FTT decision, the review of the ASA, and then Dr. Heke's evidence, the tribunal concluded that the issue had not been put, and the principle in Latter was applicable. Judge, we say respectfully that the assumption of that position was not reasonable, and neither was it consistent really with the intent of the decision in Latter. So the first point we make is that it's relevant and important to note that the decision in Latter was fixed on what were, it's fair to say, some fairly extraordinary deficiencies in the articulation of the Secretary of State's case. And so I think the way that they were referenced, if we turn up the decision in Latter, which appears at tab 17, And we go first of all to page 327. And this is a case, a protection claim by a woman from India whose claim was based on her conversion to Christianity, but there'd been a preceding determination in respect of her and her child, one of her sons who was now an adult, where it's concluded that she and their son could return to India together. The argument that was for the first time is identified at paragraphs 13 and 14 at page 327 by the Secretary of State was to the effect that that son, in respect of whom there had been previous findings, could return to India with his mother in another context. That was a person whose presence and facility to relocate was a matter which should have been weighed when assessing internal relocation. So at the Upper Tribunal, for the first time, the Secretary of State says, well, you have this other child who can go back with you, and therefore it's not unreasonable for you to relocate. And what was pointed out by the Upper Tribunal in latter was that this issue, as pointed out in paragraph 19, it wasn't raised in the Secretary of State's decision letter. It wasn't expressed in argument before the tribunal, the first tier tribunal. That's referred to, I think, that's paragraph 16. And then at paragraph 26, there was no review from the Secretary of State, despite one being directed. And I think there was also the point made that there had been no cross-examination of either of the witnesses with regard to the issue of relocation. That's mentioned at paragraph 30. So the case just wasn't put at any point in any way, shape or form. An internal relocation had been raised, but not by reference to this particular issue. And one of the points that the tribunal made was that there was a relatively optimistic, if not radical submission made by the Secretary of State in favour of the admission of this issue. And I think it's set out at paragraph 31 on page 330. The Secretary of State's ground of appeal evidence is a misconception that is sufficient for a party to be silent upon or to make an express concession as to an issue for a burden to then be placed upon a judge to consider all potential issues that may favourably arise, even if not expressly relied upon. In simple terms, this amounts to a judge being required to search for and consider an obvious point, though not so obvious that it was raised by the party at the hearing. Yeah. And then it goes on, Your Lordship mentioned the reformed appeal process and how that now operates to establish requirements with regard to avoiding judges having to trawl through papers to find what issues are. But I think it's important to understand the context in which this position is, these principles are articulated in latter. It was an extraordinary case, an extreme series of failures by the Secretary of State to articulate a position, and a rather extraordinary submission made that essentially...
So are you submitting that the principle that's articulated in paragraph 31 is confined to facts like that?
I'm submitting that certainly it would be that character of omission that would inform what is a relatively, what is not relative, but which is a radical position to assume in respect of decisions that impact on fundamental rights.
But they go on paragraph 33, it's the second half, paragraph 33, starting if by the conclusion of the hearing a party hasn't asserted reliance on an issue, a judge can properly proceed on the basis that it's not a matter upon which they're required to reach a decision, though a judge will be aware of the likely lack of procedural legal knowledge when an appellant represents themselves. Blah, blah. So that's put in very general terms. It doesn't say it's only when it's an egregious error. It's the requirement for the party to plead their case.
Indeed, Your Lordship. But I think the way we would put it in this case, that there's not been a failure to plead the case. There's been a failure to plead the case or to communicate the appellant's position in a sufficiently coherent way to enable the judge to understand what was being put. So it's...
Sorry, so what are you accepting there has been a failure to do in this case?
Well, I'm saying that it certainly could have been put more clearly than it was put, but not that it wasn't put at all.
You went on to say it was a failure to communicate. It wasn't a failure to plead, it was a failure to communicate the case as effectively as it might have been.
So what I'm saying is that it was put, but it could have been put more clearly. And so this is not a latter style case. This is a case where there is, if there is anything, there is a.
But isn't the first tier tribunal, and clearly I've got no knowledge of the judge at all, like Judge Bagwell, but she comes across as a detail person. And in paragraph 9, page 101, the agreed issues are, therefore, and we're all familiar, bang, 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 and number 4 and number 5 are the two that we're now still concerned with. And whether it's not pleaded or it's a failure to communicate, it's just that the point isn't even there, is it? There's not a whiff of it.
So I think it's important to understand what the judge is drawing from there. So the judge is drawing from the ASA. The ASA appears in the supplementary bundle at page 228.
Thank you.
And the relevant issues are set out at page 230 under paragraph 16. And as we established this morning, those issues were developed to include an additional point in the new matter submissions subsequently. But for our purposes, it doesn't matter because the relevant issue is at 16.3. Yeah. Now, what is a party required to do with regard to the practice direction that was operative at the time? That practice direction appears at tab 26 of the authorities bundle.
Thank you.
And curiously, the only reference to the construction of the ASA is included within the interpretation section, which appears at page 650, not within the body of the practice directions. Nothing turns on that. It's an unusual construction.
Right.
It's right at the back of the authorities bundle.
Yeah, but in terms of the point.
The point is that when you read that, what you see first of all is the repeated reference to the use of the term brief and concise. What's being sought is a.
It doesn't mean omit anything material.
No, I'm not seeking to extend it, but the point is that it's requiring precision, and it specifies as well that first of all, a brief summary of the factual case, a schedule of issues, and then at 3, a brief appellant's brief submissions on those issues, which should state why they agree with the respondent's decision, and that they should be at A, be concise, and not at D, not include extensive quotations from documents or authorities, and at E, identify but not quote any evidence or principles of law that will enable the basis of challenge to be understood. And so the basis of challenge, we say, is clear from paragraph 16.3 of the ASA on page 230 of the supplementary bundle. The assertion is straightforwardly whether the appellant's removal would breach Article 3 ECHR due to the severity of her health conditions and the unavailability of treatment in the DRC. That's the issue as it's articulated, and then that issue is developed briefly and concisely in the ASA itself as required by the practice direction. If you turn up page 234, under the heading real risk, by reference to health and intense suffering.
So this is page 234 of the supplementary bundle.
Yes, Your Ladyship, sorry. What you have there, the critical parts of it, would submit, are those relating to the citations of the expert report. For example, at paragraph 34 and 35 and 36, and we've looked at these already actually in the course of our review this morning. But what you'll notice from those extracts is that each of these extracts repeatedly referencing the support which the appellant gets from her daughter, P. So the first paragraph at 34 cited is paragraph 5.4.2 of Heke's first report, In the first line, which we read earlier, without the support of her daughter, Anne's quality of life would be severely compromised. And then the concluding sentence, should Anne not receive a current letter of support, I believe function would deteriorate. So that's the first. The second, 35, is from, again, these are all from the first report because the second report hadn't been prepared at this stage. Paragraph 35 is a reiteration. Second sentence, her inability to fend for herself and to not have the support of her daughter to attend to her care needs, in my opinion, will lead to further significant deterioration in mental health. And then at 36, the final reference at 5.5.1, second sentence, the appellant has, in my opinion, lost many of her self-care skills dependent on her daughter for her care needs. I do not believe she can cope alone without support in DRC and will very quickly deteriorate. I appreciate there are other considerations being referenced there, but what is critical and consistent is reference to the daughter, the principal carer.
You've got to read the conclusion that's drawn from this material in paragraph 39. In the light of the above, the appellant has been able to access support for her care needs and or medical treatment for her health conditions in the DRC and would therefore suffer so and so, so and so, so and so. There is no discrete reference to the effect on her of not being looked after anymore by PE in the DRC.
I appreciate that in that very brief kind of encapsulation, it's not referenced, but
if the criticism is that the judge should have spotted the point, but counsel failed to make the point, having set out the very material you've just taken us to, it's very hard to see that the criticism of the judge could be sustained.
all I draw from it is that in the communication of the evidence, even if it were the communication of the very summary proposition that is advanced to found the Article 3 case, the communication of the evidence indicates the importance of that connection and the implication of the loss of that connection for the appellant's deterioration. So that's it's not all I have to say.
No, but
it is the first
as far
point.
as you can take that.
But the significance of this, Your Lordship, is this: that this is not an instance where there is not communication by reference to evidence, which is what Latter requires, about an issue which we say was before the tribunal. So it's not, as was the case in Latter, a complete ignorance of the issue. It may be
There's reference to the evidence, but it isn't tied into the conclusion that you are now asserting the FTT should have drawn from that evidence, a conclusion which is not asserted in paragraph 39 of the spoken argument.
it isn't.
It's just not there.
I accept that. I can't make any more of the skeleton than I have, save to say that I distinguish Latter in the sense that this is not an instance where the matter isn't, at least by reference to the evidence, being aired at that point, even if it isn't being advanced explicitly. And it is important to remember, Your Ladyship, that the case as it was put in the ASA, because the ASA dates from the 21st of October 2022,
No, I'm aware of that.
proceeds.
But there was a further communication with the FTT, which is in the bundle,
Yes.
and as I read that further communication, this point wasn't drawn out in that communication either.
That is correct, Your Ladyship.
Right.
That's at page 59, the new matter submissions. But it is important to recognise that those submissions were more particular to the introduction of a new issue. New matter submissions are about obtaining from the Secretary of State a concession to admit.
But there was also an express application to amend the grounds of appeal in that communication. So it was an opportunity which could have been taken to say, oh, and by the way, there's a little refinement or tweak to our Article 3 medical case as follows.
Yes, that could have been done, Your Ladyship.
Okay.
But I think that I would just say that the purpose of those submissions was very particular. And so, but your Ladyship is right. I mean, I can't disagree with what you say. But what I do say, though, is taking from that perhaps imperfect platform, we step into what happens next. And what happens next is we have the hearing before Judge Bagra. And we have the benefit a benefit which the Upper Tribunal didn't have. There's a benefit in my submission, although I'm already conscious of the observations that were made by the court with regard to how helpful the record of proceedings might be to the case I'm trying to put. But we have the record of proceedings, the Upper Tribunal didn't have it. And I would make this observation, that if...
Could you have asked before the Upper Tribunal for the record of proceedings to be made available?
I think had the Upper Tribunal in its grant of leave flagged that it had concerns that the issue that was now being advanced was not one that had been advanced.
Quite a question I'm asking, but anyway.
Well, I'm getting it. We could have asked for it with leadership, but we
Yes.
had no reason to
We
expect.
weren't on notice that, yeah.
And I do make that point. If a tribunal is going to adopt the latter stance, then it should equip itself with all the relevant information before it advances that proposition, which is potentially extremely prejudicial. And it was open to the tribunal to seek the record of proceedings and to review it for itself. Now, you may ultimately determine that it would have made no material difference. But I think in terms of any observation you make about the application of the latter principle, that is a point of importance.
So do you want us to go to the record?
If you could turn up the record of proceedings, it's in the supplementary bundle. It begins at page 3, but the relevant parts, Ms. Capel's submissions, which on the Article 3 issue begin at page 52. We do say that read, particularly in the context of what Ms. Capel subsequently says in her statement evidence, we do say that what is said here is consistent with the advancement.
Just pausing there, how does her statement help? I mean, how does it add to the actual record of the proceedings?
Well, it assists in at
How?
least.
It just says, well, I think, you know, if you look at it, that it's there. But we're not interested in her opinion about whether it's there. or not.
If for some reason we didn't have a transcript, then it might be more important to hear what she has to say about it. But we've got the transcript.
That is true, but it's also true that it comes back to the point I made at the beginning, that this is not an instance. What you may conclude is that Ms. Capel did not articulate the argument with sufficient clarity for the judge to extract it and rule on it. But that is, again, a very different situation to the one that Latter was fixed on, and from which that very draconian position was assumed by the Upper Tribunal in Latter. And that what we say is that one has to be cautious in cases of this sort, which concern protected, issues of protection, about attributing significant consequences to the person's facility to advance their case as a consequence of arguably imperfections in the way that the representative has articulated the argument. It's not that it's not put with sufficient clarity, but that is not what Latter is about. And so,
But if it's not, or to use the phrase, in the ASA, and it may be said that she didn't articulate or communicate the issue effectively to the tribunal, how do you nevertheless say it was before the tribunal
that's
as an issue?
That's a different question to whether the latter principle should apply, because the alternative approach that the Upper Tribunal could have taken was that we will review.
That cut across you, but Latter says in terms, I've read it out already, if by the conclusion of the hearing a party has not asserted reliance on an issue. Well, if they haven't asserted reliance on an issue, they haven't.
Well, the appellant's case is that it was asserted. What we say is that the judge did not understand the submission made, and that's not a criticism of the judge.
Well, then we need to know what the submission was. So where do we find it on page?
Where do we find the submission?
On page 52. Otherwise, it's an unfair criticism of the judge.
I wasn't intending to criticise the judge, and I don't.
Sorry, it is a criticism of the judge.
Because
you're saying
Okay,
she
you're
failed
right.
to
Your
understand
logic
the
is
submission.
right.
I mean,
Yeah.
you can't dress it up.
Right, well,
any
let's
other way.
not
So
avoid going to the transcript where we are at page
Transcript.
52.
Your Lordship, there's two aspects of it that we say are important. The first begins midway down the page with the word OK. It says, turning to the question of Article 3 and AM Zimbabwe, we appreciate remains a high test. The tribunal has a good understanding of the obviously already of what the test is. We say it shouldn't be in dispute that she's seriously ill. It isn't. In terms of the consequences for her, she will return to the DRC, and whether or not that would trigger a rapid, significant, and irreversible decline, refer to Dr. Heke's report. Now, the references there are significant. Paragraph 5.5.1, 5.4.1, and of the first report, and then again, in particular, 5.2.1 of the second report. Your Lordship can turn those up, but my submission to you is that each of those, again, are aspects of Dr. Heke's report where emphasis is placed on the dependency and relationship between PE and the appellant.
What she submitted, and just beneath the references, which is understandable, she does not have the capacity to fend for herself independently.
On any level.
Yes, which is true. I mean, that's not...
Well, that's fairly easy to grasp.
The deterioration is likely to be much more severe if she were returned to the DRC and she wouldn't have the treatment or the support she requires.
And that is the nub of it, Your Ladyship. That is the submission. Because the treatment and support she requires, by reference to those preceding aspects of the...
Well, we've looked exhaustively at those passages, and we've already suggested that there's an ambiguity about whether she is factually getting the support she needs from the daughter, or whether the fact that she is getting it from the daughter and from nobody else is critical.
Yes, I agree. We've reviewed it, and that is a conclusion that the court has identified. But the reality is that this is a submission being made by the appellant before all of these issues have blown up. And so the submission that's being made, the advocate at this point, not unreasonably, advance this position as being the position that we advance to you. The fact that the judge subsequently interprets those passages, or the Upper Tribunal interprets those passages as incapable of informing the assertion that's being advanced, is a different issue.
But your client's case was put differently to the first tier tribunal. It was that there will be no support in the DRC. The families spread to the four winds. We don't know where they are. And so it was stark. It was, this person needs support, as she plainly does. There won't be any support over there. In the event, as we know, the judge of the first tier tribunal didn't believe that and concluded that there would be family support. Your case now is that even with family support, even if the sons and their partners or sister or whatever rally round, it is the loss of PE herself and the move itself which will be unstabling, and that will cause. And that's a different case, even giving the reading of this passage we've looked at, the most generous interpretation, because it wasn't in the advocate's mind, it wasn't her case at that stage that there would be people in the Congo who would be there, and the problem was losing PE.
The point my lord just made is supported by the submission that's recorded at the end of that paragraph. The evidence of all the witnesses today has been there are not the family members in the DRC who they're in contact with, whom they know the circumstances of, who would be suitable to provide the level of care their mother now needs and blah, blah, blah. So it's all in the context of a case that was there will be no support for her in the DRC.
Well, just take you back to that the preceding sentence just above, and I just refer you to paragraph 37.
Yeah.
What is being said there is she won't have access to the treatment she requires and the level of support she requires. It's not an assertion there that there will be no support whatsoever. And I concede that then there is reference to the evidence and the absence of any support, but it is possible to construe that part of the submission as separate from the subsequent.
Go a lot further than saying it's possible to construe it in a particular way. You've got to say there is no other way of construing it. Because unless there's no other way of construing it, the judge's approach was open to her.
I submit that I don't have to go that far in order to avoid the impact of Latter. Because Latter, as we'll look at in a moment at the decision of the Court of Appeal, in other. There are concerns about the stringency of latter, and consequently we say that latter needs to be applied with some caution in certain instances, particularly where there are fundamental rights at stake. And this is, again, coming back to our primary submission, this is not an instance where there is no, we say, there's a complete failure to articulate the argument. It's an instance where there is a failure to articulate the argument with precision.
Well,
But I won't repeat myself.
Made the point.
No.
If we could, though, before we leave the record of proceedings, look at paragraph, or bottom of page 52 and over to 53. The submissions do go on to state, in relation to N specifically, this is talking about the family member in the DRC. We know the witness from P that her mother requires intimate care as well as constant supervision as a relevant factor. He's living with friends, goes on 24/7 way that P is able to be, and Hector says is absolutely vital. She says that the appellant cannot cope by herself, supplementary bundle 24. In my opinion, since the last assessments, quoting from Hector presumably, the level of support needs has only increased. She's entirely dependent on her daughter. For additional support, extended family in the UK, P struggles with her own severe physical.
I mean, this is the second or the third time we've seen this
Yes.
passage. We're
But
familiar with it.
But this point again, Ladyship, I'm making is that the issue was there. It wasn't grasped, and that is a failure of the advocate. But that is not a failure of sufficient gravity to cause latter to be applied. The option was available to the Upper Tribunal to take a different course in this case, and that was to review for itself whether or not the proposition that was then being advanced was one that was sustainable on the evidence. Indeed, a form of exercise that we engaged in to some extent this morning. And in circumstances where there is ambiguity as to the evidence and ambiguity as to the way that the submissions are put, both in writing and orally, that is not a scenario which is compatible with that which led to the principle elucidated in latter. This is not an instance where the appellant has failed to prepare an ASA, for example, which is what happened in latter. This is not an instance where the appellant...
We know that you've already explained that there are differences factually between this case and latter, and we've gathered that.
Well, the final point is the statement of Miss Capel, which appears in the supplementary bundle at page 237, where she says, at paragraph 4, that it's her recollection that she did rely on the significantly detrimental impact of the appellant of separation from her family in the UK, especially her daughter in primary care, as a factor relevant to the Article 3 ECHR, whether Article 3 ECHR would be breached by removal, and goes on to say plainly it was relevant to the test elucidated under AM Zimbabwe. Now that's, she acknowledges ultimately, and you have the benefit of the record of proceedings, whether or not that was indeed...
Well, is she giving evidence to supplement the record of proceedings, or is that her summary of the effect of the record of proceedings? Because I don't really understand what weight we're supposed to give this.
She's giving evidence that at least part of what you've read in the record of proceedings was intended to be a submission to the effect.
Well, that's her subjective view. Aren't we solely guided by what was actually said to the FTT?
Well, you are guided by that, perhaps, in terms of what the FTT at that moment was required to consider. But you're not guided by that with regard to what the Upper Tribunal was enabled to do with regard to the application of the latter principle. Because imagine the situation as this, Your Ladyship, and indeed the situation that's now before you, is that the position is that there are references in the written argument, there are references in the oral submissions, and there's statement evidence from the advocate saying this was what we intended to articulate. That is not a situation where the appellant is coming before the Upper Tribunal saying, I've just thought of this new issue that I now want to air, and seeking to introduce it. What it is an acknowledgement that case was put, but it wasn't put in a way that could be accessed by the judge.
But like my lady, I can't see where this can take us beyond what we can read in the transcript. And it's paragraph 4, it's my recollection I relied upon, but the proof of the pudding is what she actually said. And that's what's in the transcript.
Well, again, we say that you can read the transcript of proceedings in more than one way. You can read it to support the proposition that we put, or you can read it to support the proposition that the only issue before the tribunal was that she would be isolated and without any family support. And so there is ambiguity. And then when you have the advocate's position that this is what they intended, you lose the ambiguity.
No, you don't. You absolutely
You
don't.
lose it in the sense of what they were putting, if not what was understood.
No, that's
You
her
don't-
that's her subjective view of what she was
Ex post
trying to convey to the FTT. We're concerned with what objectively was conveyed to the FTT, and the evidence for that is the transcript. I'm just not following your submission about this evidence at all, I'm afraid.
Well, the essential submission is that what you're concerned with when considering the application of the latter principle is a wholesale failure by a party to put a case at any point, or any effort to put a case by reference to submissions or evidence at any point until the case is advanced to the upper tribunal, where they then happen upon, I think the language of latter, isn't it, at paragraph 33?
Is that tab
Tab 17.
17. Just let me find it.
It's page 330.
I beg your pardon.
No place for hiding a jewel of a submission.
Forgive me, what paragraph?
34.
That's the one that I
We
wanted.
consider there's exists a duty on the parties to identify relevant issues of their own motion. No place for hiding a jewel of a submission in the hope that it will purchase favour on appeal. A party that fails to identify an issue before the tribunal that it subsequently asserts would have been essential for a judge to consider is unlikely to have a good ground of appeal before the upper tribunal.
This wasn't an attempt to hide a jewel of a submission. This was a failure to.
No, yes.
That's our submission.
Can I just ask a question about 33? Which refers to the commencement of the hearing when a judge requests clarification as to the outstanding issues. Is that a procedure which is typically gone through at each of these hearings?
I meant to draw your attention to that, actually, Your Lordship. Not always. I mean, I don't appear in the first tier tribunal as much as I used to, but it depends. It very much depends on the individual judge.
Certainly good practice.
I think it's right, and I would say that
This judge, I think, in the FTT did say it's agreed between the parties, so that possibly implies that rather than just taking it from one party's skeleton.
In some discussion.
Yes.
Yeah.
But we had the.
Can I ask another question? Is there a statutory duty to give reasons on the part of the tribunal? There may be a common law duty to give reasons.
I don't think that there is.
Are there inquiries procedure rules, for example? Oh, sorry, not inquiries procedure rules. Forgive me, that's a different context. Tribunal procedure rules.
There are first tier
Because they
tribunal
often
procedure rules.
contain a duty to give reasons.
I would have to check how I would imagine it would.
If we go to the general public law principles of the duty to give reasons, and House of Lords cases such as Save, and I think it's South Bucks, the courts have laid down repeatedly that even where points are raised, a judge does not have to go through each and every point. They deal with I think the magic words are substantial, controversial, or principal issues.
That's
Sorry, I think
you carry on.
We do have to think about the obligations that this court might be putting on judges in determining these cases.
So to address your first point with regard to was there communication at the beginning of the hearing, from my reading of the record of proceedings, there was not. I did
There could have been a
scrutinise.
question, actually, it could have been put to counsel.
Yes, it could, and I don't see that there was any engagement at the course of the commencement of proceedings with regard to
No,
the.
the counsel could have been asked, did the judge do that? Did he go through what we see as the issues in paragraph 9? And if, by the way, she did you get up and say, that's not the only issue?
But that didn't happen.
Because we've got the transcript.
Oh, I see.
Yeah.
It's not there.
It's not there in my reading of it anyway. So that didn't happen. As to your second point, I'd have to check what the first tier tribunal procedure rules say, and I acknowledge the general propositions about reasons. I'm not in a position to address you on that, how that principle operates, but I would make the general submission that certainly in the context of cases concerned with issues of this sort, there is a heightened obligation to engage with issues that are capable of affecting a person's access to protection.
That's something you said before, and it's very interesting. If there's a heightened obligation on the part of the tribunal to deal with such matters, isn't there a heightened obligation on the part of the advocates?
Absolutely.
It's a collaborative process, isn't it?
And I agree with that, Your Lordship, and that's what LATA is all about. Is
I mean, there are other principles perhaps as well. I mean, from the general common law, in litigation, parties have an obligation to put their points that they want the tribunal to adjudicate on the table. There's the principle of finality in litigation, because otherwise the flip side of all this is you can say, well, even if the point wasn't sufficiently articulated, we get a second bite of the cherry.
I don't disagree with the desirability of clear articulation of all the issues, but at the same time, we have to deal with the situation that's before us.
That's raised in the common law. That's Henderson, abuse of process, Johnson and Gore Wood, that line of cases.
But we're not in that territory here.
Yes, but maybe it would be refreshing to encourage those who participate in these appeals to actually make sure they are putting the real points that they want to be determined on the table, and there's no scope for misunderstanding. I can't see, but if I may say so, your point about the importance of fundamental rights is potentially double-edged, because it cuts both ways. It should actually put an emphasis on the advocates to make sure that these important rights are being properly dealt with by them.
And I have absolutely no doubt, Your Lordship, that Ms. Capel and the author of the ASA will certainly be apply more precision to the way they articulate this kind of argument in the future. But it is the gift of hindsight, isn't it, to be able to say, well, this is the case we put, but it wasn't put with...
It may reflect the emphasis that was being placed upon the issues at first instance. The emphasis was on the asylum claim. There was obviously the very important Article 8 claim, but it's subsequently that more emphasis perhaps has been placed upon Article 3 and this particular facet of it. And we see the arguments perhaps being readjusted.
I think that's...
It's also the fact that the case in the FTT, sorry to bang on about this, was very much based on the contention that the appellant would have no care or support in the DRC because none of the relations, for whatever reason, they couldn't be contacted, they weren't available, and the only one who was vaguely available was a chap who wouldn't be able to do it all the time. That was the case. The case that was put at the FTT was there'll be nothing in the DRC, though yes, there will be something, but it won't be the same as being cared for by PE. That just wasn't put in the FTT because it was inconsistent with the primary case.
We say it wasn't put with the emphasis of the primary case, as you put it, but it was put. That's our submission. And it isn't inconsistent with the primary case to say that not only will there be a lack of care on return, but the appellant will also be exposed to, would in any event be exposed to conditions which would be inhuman and degrading by virtue of that return, and the reduction in her condition as a consequence of the destabilising effect of that return, where she loses all of her established carers. So it's not inconsistent. It is actually the one fortifies the other. And what, as I said earlier, this morning's submissions is that we've lost one limb of it, we're left with the other, and it's that limb about which there is perhaps an imperfection in the way that the position is communicated, but not that it's not communicated at all. And I'm just encouraging this court to not to recognise that the position in Latter was on an extreme set of facts, and this case doesn't fit with those facts. It fits with a situation where the case has not been advanced.
Yes. We've covered that.
Do you have that?
Can I just ask, you use the word limb. I could see, in some cases, we talk about an alternative limb. So if I don't win this way, I put my case another way in the alternative limb. I mean, in that situation, you would have to make it clear to a judge that there was an alternative argument you were relying upon.
I've been on my feet for quite a while, my lord, and I may be that I'm not. My language is not perfect at the moment.
No,
but when I talk about, we are holding both arms out together. These limbs are joined.
Yes, but
and
I'm just proceeding by way of analysis. I mean, if that be right for where you have an alternative argument, how can it be if it's how can it be materially different if it's an important strand to your case, which is additional? I have not just simply one point; I have two.
I don't see what's being said, if I followed it correctly, as alternative. It's a sequence.
Oh, yeah.
I think your client's case, as it now is seen in the full, is that she will be grossly disadvantaged by losing the care from PE herself. She will be harmed by the very journey and the whole process of going back to the DRC, even if she's met by the most kindly people at the other end. She'll be completely harmed by that. Also, it was being put below, she won't be cared for properly in the DRC. Well, that side of the argument is gone, but your case is that anyway, those first two elements were always there and should have been taken account of. So they weren't alternatives, they were stages, and you may have lost stage 3, but stages 1 and 2, you say, were before the judge. I got that right.
I like the word element. More neutral.
It's a better.
And it's a better word. It can cover more situations. What I was struggling to say ineptly was that if you had an element which was an alternative, clear, you would have to make that plain to the judge. How can it be materially different if it's a similar sort of point? Not an alternative element, but an additional second element.
Yeah, further element.
Unless it's insignificant, which of course in your case it would not be, then you need to mention it.
And we say it has been mentioned. And there we go. That's where we are. I mean, I think
pick up a bit of
the last.
Can I just pick up a bit of jargon?
Sorry.
My lord was looking for a phrase, and it may be. I'm looking at the subheading of latter, principal controversial issues.
Yes.
And that comes from, it seems to me, the middle of paragraph 33 on page 331. If everyone's got that, about 5 lines down. The whole sentence is, the application of anxious scrutiny is not an excuse for the failure of the party to identify with the available procedural requirements those issues which are the principal controversial issues in the case. Now, I don't know whether that's a phrase that is current in immigration law.
Well, it's interesting.
Administrative law.
It certainly is in public law and in the duty to give reasons.
And you know, the equivalent cases in the employment context.
Well, it's therefore a particular note. This is not just any judgment. It's a judgment by Mr. Justice Dove, as he then was the president of the court, and a very seasoned Upper Tribunal judge who were looking to make wider points than simply decide the case. That's the phrase they use. So I put.
And I acknowledge that
down.
they frame that subsequently by reference to the anxious scrutiny obligation, and so I see that.
Good.
Final points with regard to my submission that the latter principle doesn't apply. I just make reference to the decision of this court in Azza, which appears at tab 20. First observation you make is that, as with latter, it's another example of a fairly comprehensive failure to put a case at all until the Upper Tribunal. I think in that instance you'll be assisted by considering, and I won't take you to it, but paragraphs 14 to 16 on page 343, or beg your pardon, no, paragraph 15 at page 382, and paragraph 33 at page 390. And what you'll discover from that reference is that apart from one brief reference, I think in a witness statement and early stage in proceedings, there's no reference to this issue. The issue there was about, I think, risk of refoulement to China. Yeah. And in addition to it not being referenced, other than in one statement, not being referenced in the ASA, not being argued before the Upper Tribunal, or the First Tier Tribunal, it was also a position which was unsupported by evidence at all. There was no expert evidence, there was no CPIN, which is country information. So wholly unevidenced and wholly unargued, and then introduced at the Upper Tribunal. And what is perhaps conspicuous about the way that the court dealt with it was that if we turn to paragraph 33, I think it is.
Yeah, 33.
Yes.
Onwards.
The court says this, the issue, as I've already noted, briefly alluded to in the witness statement, the point not appears to be the subject of cross-examination. There's apparently no submissions on the subject to the FGT, therefore hardly surprising that the question was not considered in that judgment. And similarly, was not subject to the ground appeal to the Upper Tribunal, which was quite extraordinary. Was indeed raised for the first time before this court. To the extent it assists me, that the issue in this case was certainly drawn to the attention of the Upper Tribunal as emphatically as it possibly could be at the earliest possible point. But I also draw your attention, Lordship, your Ladyship, to paragraph 35. Lord Justice Bean, I think it was, expressed some caution about the latter principle, identifying by reference to the position of this court with regard to the management of issues that are not introduced at an early stage, which was identified as being more generous than that in latter. He says this at 35: I accept Mr. Owen's submission that we should adopt latter in the present case, since this was what the Upper Tribunal would have done if the point had been raised for the first time before it. I would leave for a future consideration whether latter would be applicable in its full rigour, where this would result in serious injustice. In the present case, I'm satisfied there would be no injustice, and then it goes on to explain that that's because there's an option in that instance for the applicant to make another application. But we say that that is a matter of importance which should be considered by this court. First, in the context of the fact that this is not an instance where there'd been a failure to comply with directions, a failure to attempt to assist the court with the communication of issues, attempt to make submissions and adduce evidence on the relevant point that's now being was advanced by the Upper Tribunal. And it is a case where that issue was capable of impacting on the disposal of a matter of fundamental to the well-being of the appellant, and the exclusion of which is capable of causing serious injustice. So those are matters that should be weighed, and recognising, as I submitted earlier, that there was an alternative approach for the Upper Tribunal, which was to just engage with the issue for itself and determine its application. But I have...
I want to make sure I'm understanding this. You've taken us to this helpful authority in the Court of Appeal, which reminds us at paragraph 33 that latter is dealing with taking of new points on appeal. Whereas the way the ground of appeal was cast before the Upper Tribunal, the paragraph 12 we looked at right at the outset of your submissions, that was a complaint that the judge had failed to deal with the point. In other words, it wasn't being said this is a new point. We did raise this point, as you've been saying, by reference to the transcript, page 52, but it wasn't dealt with. Now, it's a different contention, because if you say, I accept I didn't raise this point before, it's a point of law and I want to take it on appeal, there's a different set of criteria for dealing with that. For example, it includes an issue as to whether further fact-finding would be required to enable the point to be taken. But it doesn't look as if the point was cast in that way. We accept we didn't take the point below, we want to take it as a new point now. Instead, it said the judge didn't deal with it.
It's said that it wasn't communicated to the judge in a way that enabled the judge to do it.
The criticism of the judge, which is what has to be shown, the ground of appeal, is the judge failed to deal with it. It's subject to the Robinson point, of course.
Yeah.
There is a distinction, isn't there?
I mean, the reality is, my lord, that the latter point latter principle would have applied with full force if the position had been advanced by the appellant to the effect that they had not put.
It was a new point.
Yes,
Yes.
and
Maybe this isn't a latter case.
that's what we say, Your Lordship.
But the case is the way it was put in the ground of appeal to the Upper Tribunal. We raised it, you didn't deal with it. That's the error of law.
Mm. I accept that perhaps that was possibly an overstatement to say that, well, it was raised. That's not untrue, but it wasn't, it wasn't, well, you have my submission.
Yes.
I'm just be repeatedly criticising the judge.
Yeah.
So,
While we're on the Upper Tribunal's decision, Mr. Jones, can I just check with you whether you accept paragraph 16 of the Upper Tribunal's determination? So in that paragraph, the Upper Tribunal records that Miss Fitzsimons accepted at the hearing that there was no evidence at all that the issue of the impact of removal itself was raised below. Is that correct? I mean, it's a yes or a no answer.
if I can just ask
Yes.
the advocate.
Not part of the appeal.
Sorry, I should just be right.
Well, I mean, just let me know in due course. I don't want to hold up the hearing.
Well, if they were complaining.
Yeah, I would have thought so. Because as my Lord the President rightly points out, you're not complaining about this on your appeal from the Upper Tribunal, so I'm assuming that you do accept that this is correct.
Okay. So the answer was apparently in footnote 3 on page 190 of the core bundle, which is a footnote in our skeleton argument.
Cliffhanger, isn't it?
Yes.
Page 190, footnote 3.
Sorry.
That doesn't answer the
How's
question.
that an answer?
The question is, did Ms Fitzsimons accept at the hearing that there was no evidence at all that the issue of the impact removal was raised below?
I'm very grateful to my learned friend who says that in fact it's the 5th footnote on page 196. Clarify in respect of paragraph 16 of the Upper Tribunal's determination, Counsel was referring to the fact that she was not instructed at the first tier tribunal. Transcript of the first tier hearing was not obtained at the error of law hearing. It has now been obtained for this court, as to which see below. The appellant's case before the Upper Tribunal was that considering whether her removal from the UK would breach Article 3, obviously including an assessment with the prior question of severing her existing care received from the family, principally PE in the UK.
With respect, that doesn't
That's not the
address
point.
paragraph 16, which is the second element, which is the impact of removal itself.
I.e. being put on a plane.
Yeah, I'm being bewildered. And I mean, the lady's question is straightforward. Do you accept that Counsel Ms Fitzsimons accepted at the hearing before the Upper Tribunal that there's no evidence that the issue of impact removal was raised below? Was that at that hearing?
Well, there was nothing before the hearing, the Upper Tribunal at that point.
Did Ms Fitzsimons accept?
Either she accepted that or
Yeah.
she didn't.
Well,
It's a simple question.
that's what the tribunal documented, and I have nothing to say that that's an inaccurate
No,
description
well,
of the
that's fairly put.
submission.
All right.
But that doesn't remove the relevance of the submission I've been making, which
No,
is
I'm
the
not. I'm not.
it's just a
asking it with
clarification
an agenda.
point.
I'm just asking whether you accepted that or not.
the
I'm
actual
surprised
removal
it's taken
exercise. There's
that
no
long
evidence.
for you to answer the question.
I wanted to make sure I answered it correctly,
Well,
Ladyship.
it's good. You've been on your feet for some time.
Hopefully I'm drawing to a close, at least on the latter point. I'm not sure that there's any more I can say about that. Just to deal with the Robinson point, essentially,
Yes, I'm just intrigued as to what if there's a transcript of this hearing, how the typist will spell latter. that sentence, but there we are.
Yeah, my pronunciation probably varied as well. But
No.
just on the Robinson obvious point, then, essentially we rely on the submissions we made this morning with regard to the test that applies under Papush-Villai and the process that's identified by Papush-Villai as to what a decision maker has to go through in order to evaluate the real risk of a significant deterioration, rapid and irreversible deterioration of care, and that includes, as we saw, I think, paragraph 186 of the Papush-Villai engagement with the effect of. Let me just get it up and make sure I get it right. 188, sorry, at page 536. So as the impact removal on the person must be assessed by comparing his or her state of health prior to removal and how it will evolve after the transfer to the receiving state. So this was an issue that was before the tribunal by virtue of the operation of the legal test and processes. And in combination with the nature of the appellant's condition and the references we've seen by looking at Heke's report, we say that it was an obvious matter that the tribunal should have grappled with, given the importance of the care arrangements in the UK, which have been repeatedly emphasised by Dr. Heke, even if the conclusion was that the existence of alternative arrangements was in the DRC was a matter which the judge could properly place reliance on. The reality is that there was still emphasis on those care arrangements in regard to the maintenance of the appellant's stability. So it was both in evidence and by operation of the law a matter which was before the tribunal, and therefore it was obvious in that sense. And I'll just draw the court's attention briefly to the case of SA, which appears at tab 19 of the authorities bundle, which is concerned with the application of the Robinson test. And the relevant passage is at paragraph, I think for our purposes, paragraph 45. And here, what the court is concerned with, is whether or not a restriction on the operation of the Robinson point, which was applied to the Secretary of State, was actually a lawful and proper restriction. And so I think it was in the latter case that the Upper Tribunal identified that there were only limited circumstances in which the Secretary of State could invoke the Robinson obvious principle. And I think you'll find the reference to that in latter at paragraph 35 on page 331. I think what's said is it can't be utilised by the Secretary of State except in identifying exceptions such as exclusion or the statutory presumptions as to criminality.
Yeah, but we're not concerned with the Secretary of State relying on
No,
it, is it?
quite right, Your Ladyship. But what the court goes on to say at paragraph 45 is this. It's the penultimate sentence. It says, with regard to the extension of the AZ principle, it must include all situations in which a point identified by the court or tribunal gives rise to a real danger of the state recognising someone who does not qualify for international protection as being entitled to such protection, as well as vice versa. And so basically what the court is saying is that the obligation to the Robinson obvious obligation is operative in instances where the consequence of accepting a matter would be that either the extension or denial of protection.
I don't know why you're taking us to a case in which it was dealt with obiter rather than Robinson itself. But anyway, I mean, we can read Robinson.
Your Ladyship is right. I mean, I think it was in a preceding paragraph that this court identified that, in fact, ASA was more akin to a question about jurisdiction as a VERC situation, paragraph 41, as opposed to a Robinson obvious situation. But I draw that to your attention.
This is not my special area, but to be Robinson obvious, the point has to be obvious on the face of the proceedings, doesn't it? And we've spent quite a significant time this morning trying to spot whether the point was made at all. How can Robinson obvious submissions apply to a case where it's not even plain that the point was before the court in any effective way?
It is obvious in the sense, if I may, the submission I made right at the beginning of the day, it was obvious to the Upper Tribunal that this was a matter that should be engaged with, and that was.
Well, they said if it was raised. Sorry, they said if it was raised, then it would have, and it wasn't dealt with. It would be an error of.
You've got to read it in the context, which is the context is an appeal in which it's been asserted that this point has been made to the FTT and the FTT haven't dealt with it. I don't think you can pray that in aid as a decision, an advertent decision by the Upper Tribunal that this was a Robinson obvious point.
But what the Upper Tribunal is not saying and doesn't say, and it doesn't actually make any comment about Robinson obvious from my reading, is it does not say that it wouldn't have that character. What it does say, it is a matter which, if it had been argued, was capable of, may amount to an error of law. And so it was a matter which...
If it had been argued.
But it was therefore a matter, if it was capable of amounting to an error of law, which could impact on the outcome of the proceedings. And therefore it was a matter of some moment. And on that logic, in line with the kind of approach in ASA, it's a matter which the judge could be expected to turn their mind to, regardless of the
if it was argued.
Well, Robinson obvious only applies if it isn't argued, Lordship.
I suppose that's right, isn't it? Well, or not argued in
Unless I can assist you any further, those are my submissions. Article 3.
And you're not? Are you saying anything about Article 8?
I am, Your Lordship. I am conscious of the time, and I'll endeavour to be.
Well, I think we're unlikely to be as lengthy with Mr.
I did express that expectation to my own friend at lunchtime.
So just, I'm hopeless looking at this clock, but it's now 8 minutes to 3, so we do have.
Yes, Your Lordship. So, just if we can just turn up the judge's decision on Article 8, the Upper Tribunal's analysis of it is brief. Page 62 of the core bundle, paragraphs 22 through to 28. And I mean, the relevant parts for the purpose of the appeal ground that's before this tribunal, really those up to paragraph 26, I think.
Yes.
And it is described essentially as a disagreement with the findings recorded by the tribunal below. We say that that's not a proper characterisation of what was being argued. It's not a question of weight exclusively. There are elements of perversity in the first tier tribunal judge's disposal, which the Upper Tribunal should have identified, which were argued before it, incidentally. Quite important to make that point in this case. We make these particular submissions about the first tier tribunal judge's determination. If we go to the relevant part of that determination, the Article 8 assessment begins at page 136 of the 37 rather of the core bundle.
235.
I'm going to align the evaluation of very significant obstacles and the assessment of Article 8 outside the rules. I'm going to deal with them together for the purpose of saving time because the principal complaints are comparable. And I'll make these general overarching submissions rather than embarking on an elaborate breakdown of the tribunal's disposal. If the first point we make...
You don't mean disposal, you mean reasoning.
Reasons, Lordship, sorry. So the first point we make with regard to the first point we want to make is regard to the unjustifiably harsh decision And I think the relevant part of that begins at paragraph 243 on page 139. And what is critical in this case is that the first tier tribunal judge accepted the existence of family life between the appellant and her UK.
Well, that's standard privifas.
Yes, but that is a significant finding, and it's a finding specifically fixed on her in her determination on the existence of real, committed, and effective ties. And so, when one is dealing with family life as opposed to private life, we're already dealing with on our submission a protected interest which is elevated. Now, the significance of that finding also beyond
what?
or beyond the existence of private life ties. Essentially, what is found here is that there is a protected interest.
There's no dispute that she's got family life with her family in the UK.
It's 244. The issue boils down to that of proportionality, and then she does the balancing.
But the starting point is that when you're dealing with family life, you're dealing with a form of an interest which is generally recognised to be susceptible to interference with only in quite compelling circumstances. And I rely on the case.
That's not right, that you can only interfere with family life in compelling circumstances.
Well,
you can interfere with it when it's proportionate and it pursues a legitimate aim, and the interference is proportionate to the aim pursued. Where do you get the idea that you can only interfere with it in a compelling situation?
I've overstated the position. I think I wanted to articulate that by reference to the facts of this case.
Right.
Because what you're dealing with in this case is not simply family life, but you're dealing with family life in respect of an appellant who is profoundly vulnerable. And so the attachments between the appellant and her family, which are described in the schedule, for example, are of a character which is elevated and unusual. And
I've just found a reference to section 117A to D in paragraph 246. So I take back what I said earlier. Yeah.
So rather than couching the submission by enhancing the concept of family life as a matter of law, as a matter of fact, in this case, in the proportionality balance, you're entitled to submit, as you have, that this lady was particularly dependent upon the particular family members that she is with now, and she's formed a bond, almost a Stockholm syndrome relationship with the people who are caring for her, and then looking at the balance of what is going to be interfered with in order to achieve what the states say. That's a weighty matter.
Yes.
So I think you're better, if I may say so, rather than looking to enhance family life as a concept under the convention, looking at the facts and putting them in the balance.
And I was going to take your Lordship relationship to the decision of Rasgar, which is at tab 6. I'll just identify the relevant paragraphs if I may, because I don't think the concepts, I hope the concepts aren't controversial, but it is an aspect of the judgment of Baroness Hale. It's page 50, paragraph 41. And just to make the point, really, the court will perhaps consider in due course what's said at paragraph 41 through to 45. But what is identified essentially is because of the acceptance of family life, even though this is a removal case, it has the consequence of converting this case into domestic as opposed to a foreign case. The consequence that the particularly heightened threshold that might apply does not apply. And then at paragraph 45, is identified by reference to case law from the European Court the fact that in circumstances of an interference with family life, there's recognised to be a particularly positive obligation to enable family life ties to develop. That's at the end.
I mean, that's all very interesting, but hasn't Rasgar been supplanted in this context by the provisions of Part 5A, which have been recognised to be a code for dealing with Article 8 cases in immigration appeals?
That only applies. That only impacts Your Ladyship, for example, with regard to private life, principally under Section 117B5, the little weight provision.
No, Part 5A is a code that deals with Article 8 cases.
It is, Your Ladyship, but
It applies to family life cases as well as to private life cases.
But specifically with regard, for instance, to the facility of a decision maker or the obligation of a decision maker to attribute little weight to Article 8 protections or interests, it is articulated by reference to private life or to specified forms of relationship which are not the relationship in this case. The other elements of 117B5 do apply. That's with regard to the questions, I think, at 117B2 and 3 about the economic interest of the United Kingdom in ensuring that people both have facility with language and are not a burden on the public purse. But in this case, the judge expressly found that the appellant was not a burden on the public purse. And that finding is recorded paragraph 255 on page 141 of the core bundle. So she neutralises that part of the 117B criteria. And she does take against the appellant the fact that this is 254, that the appellant doesn't speak English, but respectfully, that is an irrational position for the judge to take in circumstances where you're dealing, if you indeed were concerned with understanding and applying the law to the facts of the case. You're dealing with a person who is seriously disabled. And it's relevant that the Secretary of State didn't take that point in her review, for example.
Yes, but the tribunal is independently obliged to take into account the provisions of Part 5A. The fact the Secretary of State hasn't relied on a point is neither here nor there. And in any event, the tribunal, if you look at 254, didn't treat those factors as determinative.
They didn't, but there were still factors that weighed in the scale.
Yes,
and so,
but they're not irrelevant.
But it is irrelevant, Your Ladyship, that factor is irrelevant. And the reason why I flagged that the respondent didn't rely upon it is because the respondent actually has a position in her own guidance that she won't rely upon it in respect of persons, we say, such as the appellant. And we included that guidance in the supplementary authorities bundle, and it appears at page 15 of that bundle. And I think you have to consider it for yourself, but it's very much...
But I'm not interested in what respondent's guidance tells the respondent to do. What I'm interested in is the provisions of Part 5A, which the tribunal is obliged to apply when it considers an Article 8 case. It's a provision of primary legislation, so we can't just ignore it.
Unless they're neutralised, Your Ladyship, on the particular facts of the case, which for example, the financial provision was neutralised on the particular facts of this case.
We've got a consideration of these factors by the FTT, and what I'm searching for is some indication that the FTT went wrong in law in its consideration of these factors, and so far I haven't heard anything to that effect.
Well, we say it went wrong in law in attributing any weight to the fact that the appellant was not conversant with English.
Help me, I'm just looking at your skeleton on this area of the case. This isn't the point, is it, that's in the skeleton?
The skeleton is framed quite generally with regard to its contentions. I concede that this particular point isn't taken, but I was identifying and responding to this because Her Ladyship had flagged the 117B issue this morning. So I'm just raising that and identifying why it in fact was a neutral.
I flagged 117B specifically. I just
the 2005,
said Part 5A.
Yes. Well,
and there are two tests which apply, and because your client doesn't benefit from any of the exceptions, my understanding is that the statutory test that would apply is whether there were very compelling circumstances over and above the circumstances identified in the exceptions, which would mean that she should stay in the UK, in short.
I understand, Your Ladyship. I think that is indeed the test, and I think it's framed in the rules which appear in.
Well, don't worry about them.
But yeah, it's an it has to be unjustifiably harsh, Your Ladyship. That's the threshold. To interfere, the consequences would have to be unjustifiably harsh. But we say they obviously are on the facts of this case.
Well, the FTT disagreed with you, and what I'm trying to understand is how the FTT erred in law in disagreeing with that on the facts.
It erred in law on two principal bases. One, in failing to attribute proper weight to the family life it found
Well, proper
existed.
weight is for the decision maker. So a submission that a decision maker failed to attribute proper weight to something goes nowhere.
Right. It was irrational for the tribunal to conclude that the impact on family life would not be so significant as to render enforcement action disproportionate. And the consideration we rely upon in particular in that connection is the judge's analysis at paragraph 248 on page 140 with regard to the fact that there will be facility for the appellant's British family to on occasion visit her in the DRC and maintain contact with her by modern forms of communication.
Right.
And we say straightforwardly and obviously, when you're dealing with a family life of the character that is presented here, where the implications of interference with that family life are significant and recognised by the judge at least at page 141253 to be periods of distress and disruption, which we say is an understatement given what we know about the appellant's condition. The recognition of that disruption and distress, which not only applies to the appellant but also to her British family, because obviously, as she recognises, all of their lives will be disrupted by this exercise. The family here will be compelled to live with a situation where the person who is a part of their family and for whom they've extended close care for an extended period and whose mental faculties are deteriorating and predictably will deteriorate more rapidly by the removal exercise, that they're going to have prospectively only very limited contact with her. And that is, we say, one of the most profound forms of interference with family life that one can imagine. And yet the judge does not recognise that reality.
So
Instead,
this is, forgive me, I'm just keeping up. This relates to paragraph
248, Your Lordship, page 140.
Yes, because what I'm doing is, as you're making these submissions, I've got a finger in the page 82 to 83, where I think that's the ground of appeal to the Upper Tribunal criticising the judge on the Article 8 points, and I'm not sure I'm seeing this as a ground of appeal, but I may be wrong. I was just picking up the references in the brackets, but to what is criticised.
I think I would read paragraph 13 on page 82 for.
That's covering it.
Yes.
Okay. That's dealing with the other relatives in the DRC and so on.
And all of the submissions we made this morning, which may not have gained traction in the way I
They
hope.
come in here.
Indeed. And in particular, the one, the submission, for example, about the implications of return and the way in which the appellant may manifest fears which are not objectively real but subjectively have substance. And so the implications for her are significant, and the implication for her and any deterioration for her has a knock-on consequence of impacting upon the whatever limited continued connection she enjoys with the family here. So this is, we say, a fundamental effective severance of family life, arguably, on one sensible interpretation of the medical evidence and the consequences of the removal exercise for the appellant, and the fact that the substitution or the persistence of, there's no actual effort to identify how family life can persist in this case by the judge. She basically says, yes, you have a real committed and meaningful family life, And then she basically says, but you can just see each other from time to time on holidays.
Inevitable consequence of removal.
But an inevitable consequence which has to be justified in the public interest.
Yes,
Your
and
Ladyship,
the judge extensively considers all those matters and concludes that removal is justified.
But the only factor of any moment that the judge fixes upon is we say the issues of language fall away, issues of finance are neutralised. Indeed, the only issue is the failure to meet the requirements of the immigration rules.
Well, that's a significant issue.
It is a significant factor in some
She was here unlawfully for a considerable period, and I think the judge found that she came here not intending to leave.
So
All of which is significant in relation to the importance of maintaining immigration control.
So the first point, Your Ladyship, is that she is still not here illegally. She is lawfully present in this country still after 6 years. She entered with leave, and she applied for asylum during the currency of that leave, with the consequence that her status was extended by operation of paragraph of section 3C of the Immigration Act 1971. So she is in fact a person who's lawfully present by operation of the law. She's also a person who made a lawful application under the immigration rules. And there were immigration rules which operated so as to enable her to advance that case, in particular by reference to the very significant obstacles test. Now I concede that that test was disposed of against her, but the reality is that she made a lawful application which the immigration rules facilitated. And in addition, she made an application by reference to the general exceptions, which also falls under the immigration rules, under Gen 3.2.2. Both of these provisions appear in the authorities bundle at documents 3 and 4. So her status here, her presence here is lawful, and she is present pursuing an appeal which was founded on the immigration rules. And so that is relevant to the quality of the interference with immigration control. What can be said is she has not yet established a right to remain here under the immigration rules. But what cannot be said is that her presence here throughout has been in a manner which is incompatible.
Being precarious rather than unlawful.
But that's a very different.
Yes, all right, I accept that.
And so that is, so in terms of the public interest, that is a significant factor. And in addition to that, the observation about intent to remain here. Well, it is relevant that no effort was taken, no point on suitability was taken by the Secretary of State in her decision with regard to the immigration rules. If she'd formulated the view that the appellant had formally exercised deception or misrepresentation in order to acquire a right to enter the United Kingdom, she could have advocated that as a ground for refusing.
But the Secretary of State's hardly in a position to do that, but you've got a clear finding in para 256 by the fact finder that the appellant, the FTT, was not satisfied she ever intended to leave the UK.
One, surely, Judge, my lady.
Taking into account her protection claim is not genuine and she does not meet the immigration rules.
But that has to be considered in two.
Well, just pausing there. Is any of that irrelevant to the consideration of this appeal by the FTT?
It is relevant, but it is not. It is not a position which the judge can fix upon without also recognising the point we made earlier that, irrespective of whether she concluded that there was an objective risk, the appellant continued to manifest a subjective fear of return.
Right.
So whatever the substance of that protection claim is with regard to its facility to establish a right to remain, when one is assessing whether it was a device to fix her residence here improperly, one has to actually consider what the appellant is describing about her understanding of fear. And beyond that too, Your Ladyship, the other point we'd make is, with regard to intent, is that, as we established earlier, this is not an individual who can speak for herself and answer to that assertion. And so this extraction of a...
Sorry, are you submitting that the finding in para 256 was one that wasn't open to the FTT?
I'm submitting that it was one which doesn't attract substantial weight given the absence of capacity of the witness. If you're determining intent, Your Ladyship, it's the intent of the individual that has exercised the facility to enter the UK that's material.
She didn't lack capacity when she entered the UK.
But neither is there any evidence from the point she entered or any assertion made by the respondent that when she entered in a manner which was incompatible with the immigration rules.
All right.
And just one point to flag up, we included in the supplementary bundle the case of LD, supplementary authorities bundle, the case of LD. I just commend to you the observations made, this is going back to an earlier point.
What's this?
The observations made by the
It's not a
Court.
bundle, it's a
I've got
it's a
it,
small
thank you.
yeah, it's Mr. Justice Blake and Senior English Judge Ward, and just speaking to this point about interference with family life, paragraph 21 on page 9, where a submission or a finding is made by the tribunal below that family life can be accommodated by precisely the sorts of considerations that this judge fixed upon, visits and contact by telephone. The tribunal says this in the second half of that paragraph, beginning, we find the reference to maintain contact with the family in the normal manner is extraordinary. Families normally live together. Family life consists of the interdependent bonds between spouses or stable partners and between parents and children, with particular strength being placed upon the interests and welfare of minor children. It's not normal for family life to be enjoyed by correspondence and occasional visits, even assuming that there were no obstacles to such visits following immigration decisions. And so, just
What weight are we supposed to give this in the context of this case?
well, that precisely the weight that the court gave to it there when finding that the disposal of the Article 8 issues was flawed by virtue of reliance on that consideration in the context of family life.
Does that mean you can't take it into account at all?
You can. It depends on the context of the particulars of the case.
Well, if it's
but
irrelevant, obviously you couldn't. But if it's relevant, is there some legal principle preventing it from being taken into account?
well, there is not.
So then it becomes a question of weight.
And your client clearly has family life rights in relation to the family in the DRC.
Well, I would say there is no family in the DRC in the Article 8 sense. There are relations in the DRC. The only people that the appellant
She would
conceivably
have, before she got on the plane to come here, anyone looking at it would say that
With
she
the
had family
grandchildren,
life
except.
rights with the family there.
with a passage of
The
4
passage
years.
of time, it falls away.
Yes. So there is no equivalent. Not that that respectfully would be a basis for interfering with the family life here, that there was family life elsewhere, even if that were the situation.
So I don't think the
Well,
first year tribunal went there, but we're not considering an individual who's going from her family life here, which the tribunal rightly held was established, to nothing.
No,
She'd
that
be
is
going
true.
back to her family and to the place where she'd grown up, to her house, insofar as she's able to understand what's happening.
And that's, I was going to say something about that, but you have it.
Yeah. Well, I think.
May I
Mr.
just
Jones,
very quickly,
Yes, you covered the ground very thoroughly.
thank you, Your Ladyship, I have nothing further.
No.
No, thank you very much. Yes, Mr. Erdast.
Thank you. Good afternoon, my lords, my lady. As no doubt you've gathered from both reading the papers and from listening to my learned friend, this case, in my submission, respectfully, is resolved by the distinction between, one, the point raised before the first tier tribunal that returning to the Democratic Republic of Congo without care at all would breach Article 3. And number two, the points not raised before the first tier tribunal, that the separation from family member caregivers in the UK, including PE per se, even with other family members providing care in the Democratic Republic of Congo, would breach Article 3, and that the impact of removal itself would breach Article 3. I just have that preliminary point which my learned friend foreshadowed earlier, and it just relates to the alternative legal point, that is that care is incapable of falling within the term treatment in the Papashvili test. upon review yesterday, it occurred to me that that point wasn't put before the Upper Tribunal by the Secretary of State, and therefore is a point which wasn't raised below, a pure point of law that wasn't raised below. Now, of course, it wasn't raised below at the first-tier tribunal, but that's because at the first-tier tribunal, the appellant was making a point both as to treatment and as to care, whereas in the Upper Tribunal, the point was simply made as to care. It follows, in respect of this point, this alternative legal point that wasn't raised below, of course, this court will be very familiar with the relevant case law as to pure points of law not raised below. In that regard, the Secretary of State is in this court's hands. What I wish to emphasise, though, is if this court is with the Secretary of State on the facts and the application of the law to the facts, then, in my respectful submission, I would invite this court not to
You don't need to go there.
decide. You don't need to go there, and would respectfully encourage this court not to go there.
Yes.
I'm conscious of the time. I'll adopt the structure of my skeleton argument, and I'll attempt to move through the factual background, the points raised before the first-tier tribunal, its judgment, points raised before the Upper Tribunal, its judgment, and so on. I'm happy, though, of course, to move faster through these sections. No doubt you'll already have a number of points.
For
And
my
of course,
part, I mean, with Mr. Jones's help, we've been through quite a lot of the detail. So only if you disagree with the reference we've been taken to, or you think there's a reference we haven't been taken to, do I think you need to say anything about it? Is that?
in which case I'll attempt to fly through so far as I can.
Well, we'll watch with awe.
I highly doubt that. Of course, the Secretary of State's case is that the factual background, what was before the first-tier tribunal and the Upper Tribunal, and their decisions are so fundamental to the resolution of this case, perhaps more so than other cases that may come before you, and hence that's why, of course, everyone's gone in such detail in them. Firstly, key points emerging from the factual background. And my first one is that Dr. Haker's response was conditioned by her instructions that A, no one was available to care for her in the Democratic Republic of Congo, and B, that she had a subjective fear. And those factual premises were both rejected by the first-tier tribunal in my respectful submission. I emphasise the latter just because my learned friend said that she did have a subjective fear in my submission. That was rejected by the first-tier tribunal. I will take you there. Firstly, in terms of no one available to care for her, I did have other references than those that your lordships and your ladyship have been through, but if you do accept the point that the first-tier tribunal, that the appellant's case before the first-tier tribunal was that there was no one to care for her, as the first-tier tribunal indeed found in the final sentence of paragraph 232, then I needn't go through all of those other passages which...
I don't think you do. That's when we've got the tribunal judge's finding.
I'm most grateful, your lordship. As to the acceptance of Dr. Haker about the subjective fear, but the first-tier tribunal rejecting subjective fear. Well, firstly, if I may go to Core Bundle 137, it's paragraph 232. And this it relates to Dr. Haker's report. And it states it has to be viewed in light of her opinions about the accumulative effect of threats received. But then the key point, I do not accept the appellant has been threatened either in the DRC or in the UK. That's the first element, 232. So that's the first element of it. The second element of it is within the it's a paragraph 239, within the context of Article 8 here, it's page 138, and it's about 8 lines down. So, firstly, so just for the context of that, 4 lines down, she brought forward her findings in respect of the appellant's mental health, in view of the opinion of Dr. Haker regarding that deterioration, which I just took this thought to, in part based, and this is the key passage, in part based on the appellant's subjective fear that she's wanted by the DRC authorities and that the appellant will be left to fend for herself, which I do not accept. Now, very, very technically, there may possibly be some ambiguity as to whether which conditions, there's the word which, conditions both, but when read in context,
Yeah.
it is quite clear, because you wouldn't say Dr. Haker's report is conditioned on the subjective fear, ... which I do not accept.
Mm.
If you accepted the subjective fear, because why say that this report's conditioned on it? And additionally, one might think that the 2 commas between A and B would also go to show, because if you removed the part between the 2 commas, suddenly you get the subjective fear, which I do not accept. It's very, very clear that she doesn't accept a subjective fear. Furthermore, just to seal the point, if I may please turn, it's page 140, paragraph 247. It's at the very bottom of that paragraph. It relates to the fears. So first, right at the top of the page, the opinion that Dr. Haker has that the appellant can't function independently, and so on, and then the condition would worsen to a severe level. And the judge finds that it's intertwined with not only her reporting of the fears, but what she says about them in her witness statement. It was before Dr. Haker and during the assessments. For the reasons given, I do not accept that was truthful. Again, going to subjectivity, not objectivity. She doesn't say, I accept that she subjectively had those fears, but I don't find objectively on the factual country background and expert evidence that they are objective. No, she says it's not truthful. Then paragraph 256, just over the page, the point that your ladyship raised with my learned friend, not satisfied she ever intended to leave the UK, and that this protection claim is not genuine. Again, goes to, in my respectful submission, to subjectivity, what was in her mind. The other relevant paragraphs that, if I may, just based on time, note down, but not necessarily take your lordships and your ladyship to, which are the source, perhaps, material within the asylum section of the judgment. Firstly, it's core bundle 125, page 125, and it's paragraph 160, and core bundle page 130, paragraph 193. Just to be, and I know this point wasn't raised this morning or earlier, but just to be incredibly clear, moving on, that my learned friends in their skeleton argument mentioned that Dr. Haker's report wasn't was accepted by the respondent. Just to be clear, the respondent accepted the diagnoses as such, but not the causative link between the diagnoses and the alleged adverse interest from the relevant authorities in the DRC. The point is that in coming to her decision, the first-tier tribunal judge didn't go behind the respondent's acceptance of those diagnoses. And in particular, in deciding putting into doubt at paragraph 232 and elsewhere the what is in Dr. Haker's report, one has to be extremely careful when reading the schedule that the appellants have provided to this court, because of course, while a number of matters would flow from the diagnoses, a number of matters may be undermined by the first-tier tribunal judge's findings. That's my first point. My second point is that there was no evidence at all in the expert evidence on reversibility of decline. I put that in the skeleton, I'll come back to it later. The third point is that there were no submissions at the first-tier tribunal addressing the points themselves, and I think you have that point. I don't think I need to go through it in detail, unless your lordships or ladyship would like me to.
Thank you.
I'm most grateful. In terms of the findings of the first-tier tribunal, I'll just read my submissions and just see what needs to be said, given the extent
So
that...
which page are we on in your submissions? Or maybe there's your speaking note.
Page 4 of my skeleton
Good,
argument.
thank you.
Yes, perhaps this is relevant. Paragraph, so the page reference 127 of the core bundle, paragraph 171 of the first-tier tribunal judgment, and if I may, the reference at apologies, there's a reference in my skeleton argument that I'm intending to correct before your lordships and your ladyship.
Oh.
Yes, this is it. It's at paragraph 16, first line. The page reference there should be 127. The paragraph reference should be 171, and it's just where the...
Right, so it should be CB 127.
Yes, and paragraph
171.
That's right, that's where the first-tier tribunal judge found that the asylum claim was untrue. And there were four aspects as to which her and her family were disbelieved. I've set those out at 16.1 to 16.4, and I don't necessarily need to go through those orally unless your lordships and your ladyship would like me to. The key thing is none of those findings have been appealed.
No.
Or at least not successfully, and are not before this court. So then moving through, this moves to paragraph 20 of my skeleton argument, and just the careful fact-finding in respect and conclusions in respect of Articles 3 and Article 8. Just to be very clear, of course, the conclusions within the asylum claim at paragraph 160, core bundle, page 125, and there's further reasoning at 2 paragraphs down at 162, that the mini-stroke in July 2020 wasn't caused or contributed to by the alleged threatening messages, which of course stands. That of course conditions the Article 3 decision. So following the acceptance that she was a very seriously ill person, then you've got that full reasoning which I set out at paragraph 21 of my skeleton argument. The key points, of course, AM Zimbabwe test set out at para 220, 222, Dr. Haker's conclusions, 223 concludes that the medication or treatment not unavailable or unaffordable took into account socioeconomic circumstances and so on, gave little weight to Dr. Cody's evidence on availability of treatment, then sets out the key paragraph of 232, which we've looked at, of course, and you looked at with my learned friend extensively, and of course, which is quoted paragraph 22 of my skeleton argument. That's fundamental in my respectful submission because it goes to how far Dr. Haker's report assists the appellant in the context of the factual findings made by the first tier tribunal. And then finally, the key finding at paragraph 233, Core Bundle 137, that even if her youngest son, N, could not support her, she had 3 other sons who may have female partners and a sister in the DRC, and wasn't satisfied that they couldn't either individually or collectively provide her with the practical and emotional support, care, intimate or otherwise, that she requires. And then we've dealt with the conclusions on Article 8. I don't need to go through them in any detail at all. I will just read through my submissions in case there's anything that hasn't.
Do take your time.
You didn't go through it, but no doubt your lordships and your ladyship will have noted the point at paragraph 238 that the family photographs for the purposes of the visa application gave a rather different impression from the evidence as presented to the first tier tribunal on the asylum claim.
Yes, well, certainly for my part, I noticed that, and I suspect the same as the case for others. And that was every picture tells a story, and that was clearly important to the judge.
Yes, absolutely, my lord.
It might also be thought that the FTT may have did deal with the argument that only PE could deal with the appellant's needs in paragraph 248, but in the context of its assessment of the Article 8 claim rather than the Article 3 claim. But the FTT was certainly alive to that issue.
Yeah. The last few lines of 238, isn't it?
Oh, sorry, I was looking at 248.
It's also, I think you're right, and I think the last few lines of 238, whilst I'll acknowledge that PE is taking responsibility, she's not established, she can't be cared for by her children and sister in the DRC.
Because there's also, if one looks at 247, the extent to which the appellant's condition would worsen without sponsorship fee, and particularly PE as opined by Dr. Henry counts in isolation, blah, 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 blah. So I guess my point, and then 248, whilst I accept the appellant is seriously ill, what is being suggested by the evidence relating to the appellant's care needs is that only PE can cater to them, and is what follows in 248. So the FTT was alive to that issue and dealt with it, but in the context of Article 8 rather than Article 3.
My lady, yes, absolutely. The key paragraphs in respect of PE and the picture drawn both below and here, that it's really only her that can provide for properly for her are absolutely 248, below at 249, and above at the bottom of 238, where it sets out that PE doesn't provide specialised care.
So whether or not this was advanced as part of the Article 3 case doesn't matter, because on the facts, the FTT rejected those contentions.
That's my respectful submission.
Yeah. And so if they're, it's a hierarchy, if they're rejected at Article 8 level, surely it would be rejected at Article 3 level. If it had been clearly raised at Article 3, if she was rejecting it, she was rejecting it.
On the facts, absolutely. I wouldn't wish to make a legal submission about any hierarchies merely just
No,
because...
well, that's my word. But
No, of course.
Yeah.
It's just merely because of what GS India mentions about, well, if you lose on Article 3, it's going to be hard to win on Article 8. But yes, absolutely, my
I was
lord.
going the other way. If you don't succeed on Article 8, then you're really struggling on Article 3.
But the point, the
You
basic
don't
point
see-
is the
yeah.
factual underpinning for an Article
It's
3
just-
claim
it's
based
just-
on this
it's
contention
just not
is
there.
not there
Yeah.
because of the findings of fact made on the Article 8.
Yes, my lord, my lady, I entirely agree.
Yeah.
I'm most grateful. The long and the short of my submission on how the judge dealt with Article 8 is that this was a thoroughly careful analysis in line with anxious scrutiny and put everything within the balance properly and gave the weight that she thought was appropriate to it. Moving on to the appellant submissions in the Upper Tribunal, I was going to focus on paragraph 12 of those, the appeal skeleton argument, but of course we have already focused on that. Your lordships and your ladyship did on with my learned friend. For the avoidance of doubt, and I don't need to go there, but on Article 8, a similar argument was put, and in a similar way, to that argument, the per se arguments on Article 3, those can be found at paragraphs 13 and 16 of that appeal skeleton argument, the one where paragraph 12 is found at page 82 of the core bundle. Your lordships and your ladyship have the decision that was made by the Upper Tribunal on Article 3 and Article 8. I don't really need to go, I don't think I need to really go through those. It's simply just noting on Article 8 that the Upper Tribunal made the decision that I would respectfully invite your lordships and your ladyship to make as to how the first tier tribunal went through Article 8, namely very carefully. As to moving on then from the facts to the law, unless your lordships or your ladyship have any questions.
No, thank you.
I'm most grateful. You've already looked at Arza and Lata, my very brief submission on those. My first point is that either a point was before the first tier tribunal judge, or it wasn't. If it wasn't, then it may be an error of law not to assess it. But if it isn't before them, then of course, how can it be an error of law not to take it into account?
Well, what do you say to Mr. Jones's submission on Lata, or Lata as I've been calling it, that's a strong case in the sense that the issue simply had not been raised in any way by, as it happens, the Secretary of State, and then it was raised on appeal. And Mr. Jones' submission is, well, this isn't quite, because it was all there, it just hadn't been formulated and put in the shop window up front, obviously my phrase, in the hearing. And that's different from Lata, which is looking simply to say, if we don't raise it at all, then you can't raise it later.
Yes, it's really the point that that your lordships and your ladyship put to my learned friend, which is Lata and then Arza in the Court of Appeal, which said for points not raised below, you use Lata, which is more stringent than the usual Singh and Das case for points not raised below. That is, you can't just have something that is either lurking in the evidence or even perhaps is prominent in the evidence. What you need, and there's very good reasons for this, which are all encapsulated in the paragraphs of Lata, which I raised in my skeleton argument. I may have further paragraphs though of Lata, which I may take your lordships and your ladyship to. But just to be really clear, essentially what Lata is a point on a wider principle. That wider principle is how the Upper Tribunal addresses points not made below, and the stringency of that. And the good reason for that, the good reasons, namely, there is this practice direction which was current at the time of this appeal. Those require written submissions from both sides as to what is and what is not a principal controversial issue. For what it's worth, in answer to a question asked to my learned friend as to where the first tier tribunal judge got paragraph 9 from, which set out those principal controversial issues, and at the very least the answer may be that of course it's in the appellant's skeleton argument, but it's also in the respondent's first review,
Right.
where the respondent says, here's what the appellant says are the principal controversial issues, we agree.
Yeah.
I'll accept that I haven't
You,
checked.
you referred to the President's practice direction as being in force at the time. It's still in force, is it? If we're going to say that LART is a jolly good thing.
There's a new practice direction, I think from November 24.
There's a note, yes.
Would it probably help
We
us
can
if
make
we...
it available.
Could you make it, we wouldn't want to be saying something that would mislead. So if you could let us have that in due course, thank you.
Of course, it is notable, just for the avoidance of doubt. Of course, the matters in the first tier tribunal were, of course, before the new practice direction came into force.
Yes.
And it's also true that the case of Arza was decided, of course, by the Court of Appeal this last
Does the new
year.
practice direction say anything materially different about ASA?
I must admit I haven't gone to it, my
No,
lord.
well, we'll see that when it comes up. Miss Fitzsimons, who knows these things, is shaking her head, so that's helpful.
The point is, and if I may turn, perhaps going to LARTA would be helpful. If I could please go to it's page 325 of the authorities bundle. I'll admit that I noted the pages. I didn't note it's tab 17. I didn't note the tabs in my notes, so it'll take me a bit of time to get to the...
Don't worry, what paragraph would you like to give?
It's paragraph 4.
That's 325.
That's 325, very bottom. And here is the question of law that arose, whether it's open to a party to proceedings to raise as the basis for an appeal, a point that wasn't one of the principal controversial issues. Of course, what I say the principal controversial issues are the points that were at paragraph 9 of the first tier tribunal's judgment. That is Little Roman 4 and Little Roman 5. I don't necessarily need to take your lordships and your ladyship there because you've seen it. And of course, it was observed that there was nothing about the 2 per se points within those. And of course, the reasoning is set out at paragraph 27 of LARTA as to why this stringent approach is taking place. That's at page 329, paragraph 27, which is that the first tier tribunal judge can properly expect clarity as to the issues on substantive hearing, because in line with that the practice direction, they can expect the parties to engage in the process of narrowing and defining the issues. Then, if I may move down to paragraph 30 over the page at page 330. First line, the robust and considered decision making starts with identifying the core relevant issues. I think perhaps your lordships and your ladyship have gone through 31. Yes, you have, about sifting through the papers and so on. I would respectfully endorse the final sentence of that paragraph 31, namely 2 competing sets of submissions. It's not 2 competing sets of evidence, which then judges need to look through. And then I know you've been through paragraph 33, but the point about anxious scrutiny not being an excuse for the failure of a party to identify a principal controversial issue, and that it's rare indeed for a point requiring anxious scrutiny that's not Robinson obvious to have eluded these reform procedures, it is relevant here, of course. My learned friend used the phrase as one can extrapolate reasonably from the expert evidence, or that it was readily ascertainable from it. Those points about per se made at the Upper Tribunal. But that's, in my respectful submission, highly different from a Robinson obvious point. As for the Article 3 medical cases, you have the tests. What I would add, just very quickly on my learned friend's citing of Appellant in Belgium, having briefly looked it up during his submissions, that case was a 17-year-old, so a minor, and was entirely under the police's control. So those are two quite substantial factors there. And in any event, of course, as your lordships and ladyship observed, it's a fundamentally different case to a medical case. As to Article 8, going extremely breezily, I just have really two authorities here. The first is just paragraph 59 of Rasgar. It's the authorities bundle, tab 6, page 55.
Is that the paragraph we went to earlier?
I don't think so.
No,
I think
it was the first paragraph we went to.
No, this one is just emphasising that it, although the possibly can't be excluded, it's not easy to think of a foreign healthcare case that would fail under Article 3 but succeed under Article 8. So it's just really that observation. Then moving on, if I may, just to GS India. It's at Authorities Bundle, page 183, tab 10, and it's paragraph 111.
Sorry, could you give the reference again?
Yes, of course. It's page 183 under tab 10.
Thank you.
And it's paragraph 111. And again, emphasising the rarity of healthcare cases that fail Article 3 but succeed under Article 8, and the reiteration of the no obligation to treat principle that really I'm wishing to emphasise. I suppose finally, just so that your lordship and your ladyship, your lordships and ladyship have it, the case of Parveen at tab 12, page 214, and it's paragraph 9. This perhaps is at the risk of over-egging the Article 8 pudding, but while, so this is just the second part of paragraph 9, where the Court of Appeal set out that they didn't find the gloss quoted from the Upper Tribunal very useful, and it's just about very significant obstacles. The point was made that there was no problem at all with the Court of Appeal with the point that it's an elevated threshold and that it won't be met by mere inconvenience. As to my submissions, therefore, firstly on Article 3, you've no doubt read the summary at page 13 of my skeleton argument.
Yes.
At paragraphs 50 to 51. And though that, in my submission, is really the essence of, and it's fundamental. Of course, I raised that distinction at the start of my submissions. Firstly, therefore, in my respectful submission, the Upper Tribunal didn't make an error of law. You'll have noted the sort of alternative cases and the way I've put that. But the fundamental point is that the separation from primary carer per se is different, a different submission altogether from the impact of being removed to the DRC without any care or family support. Insufficient for a matter to be before the first tier tribunal, that it exists within the evidence short of being Robinson obvious. The submission had to be specifically made. And just 3 reasons why the Upper Tribunal respectfully didn't make any mistakes. Firstly, and I don't think there's any issue as to this, but the Upper Tribunal must be taken as being aware that the point that the change from UK caregivers to no care at all was before the first tier tribunal. And the reasons for that are a twofold. Firstly, the first tier tribunal addressed Ms. Capel's submission on this point squarely and lawfully at paragraphs 230 to 233 of the first tier tribunal's judgment. And then if one goes to Core Bundle 61, paragraph 18 of the Upper Tribunal's decision, the Upper Tribunal refers explicitly to para 233. And this court might think that that indicates that the Upper Tribunal will therefore have read paragraphs 230 to 233, where that first tier tribunal addressed those submissions of Ms. Capel. Secondly, and I think I can be brief about this, the Upper Tribunal is likely reacting to my learned friend Ms. Fitzsimmons' grounds of appeal, namely paragraph 12 as we've been through. And in my respectful submission, Ms. Capel's submissions on the appellant's primary case, which you've been to, of course, during the course of this morning and this afternoon, they don't address, as rightly your lordships and your ladyship observed, don't address the removal from PE or the removal process per se, which is what the grounds of appeal to the Upper Tribunal asserted, and which was therefore what the Upper Tribunal could and did react to. Thirdly, my respectful submission, there was no evidence in Dr. Haker's report specifically going to those 2 per se points, and Dr. Haker's evidence was based on the 2 factual points that the first tier tribunal didn't accept in paragraph 232, which of course you've seen. And so, in my respectful submission, there also, therefore, wasn't the evidence from which such a submission could in any event be made with a substantial degree of success. It follows that in my respectful submission, once first tier tribunal judge rejected the rejected the Article 3 case on its facts, there was no alternative case, as your lordships and ladyship have observed, on lack of continuity of care, caregivers per se, in the UK, or removal process per se, and therefore the Article 3 case at that point was dead in the water. And for the reasons that you've already put to my learned friend, this wasn't a Robinson obvious point. As per the Upper Tribunal, there wasn't expert evidence going specifically to those points. And it eluded the first tier tribunal and the advocate below. Just though, because it is relevant, please may I turn back to GS India, but this time page 178 of the authorities bundle, just on Robinson obviousness, because there's a very helpful, it's back, yes, tab 10, 178, it's paragraph 89, And if I may ask your lordships and ladyship to read the observations on Robinson obviousness, and there the quote is explicitly to Robinson, because that will no doubt assist. In your assessment of whether this is or is not, or these are or are not Robinson obvious points. I hope I said paragraph 89. If I,
Well, that's where the quote obviously is, so that's
I'm
where
grateful.
I've gone.
Is interesting to see it's referred to as lamentable patois.
indeed,
But it's a point that's not only arguable, but a point that has a strong prospect of success if it is argued. Nothing less will do.
Yeah.
those are my submissions on
And
the
then
primary.
the next one, the Robinson hurdle is a high one.
Indeed.
Yeah.
Those are my submissions on the primary case that the Upper Tribunal didn't make an error of law. I do have, of course, the alternative case, which is the other side of the coin of those submissions, that the first-tier tribunal considered the points sufficiently and without error that were put to it, but I needn't
Don't think
trouble
need
you.
to- that's on paper, we've got it.
I'm most grateful. Similarly, if there was an error of law, it wasn't material, that's also on paper, and your lordships and ladyship have that, unless you would like me to
No, all right,
address
yeah.
you further.
Thank
I'm
you.
most grateful. And you also have on paper the legal question as to whether care may constitute treatment, which I'm very much hoping that your lordships and ladyship will not decide.
Commendably frank.
It's not often we have an advocate question about the case they've pleaded. But,
Well, not because I'm not confident that it's
no,
the case.
Just not necessary to go
it shouldn't be there. Yeah,
No,
yeah.
indeed. I felt at the time the skeleton argument compelled to go there, admittedly based on a misreading of my learned friends, the change in that header of ground one, which
Yeah,
didn't
don't
fall
worry.
as a matter of law. I'm most grateful. Therefore, moving to round 2, Article 8, I do have submissions on it. In the skeleton argument, of course, I set out 7 submissions. They boil down to 3 key points.
So
and
we're
two-
here at paragraph 74, I think, of your skeleton.
That's right, my lord.
Yeah.
Yeah, they boil down to 3 key points and 2 responses to my learned friend's skeleton argument. As to those, firstly, perversity is a very high bar, as per the case law in the skeleton argument. The second point is that first-tier tribunal Judge Bagral, as the tribunal said, carefully weighed all relevant factors in the balance. You have seen that from for yourselves at paragraphs 235 to 257. It's 23 paragraphs going through Article 8. Weighed the points in favour of the appellant and against. I'm just looking at a submission just to check if I wish to make it. Yes, it's just to clear up a point in my learned friend's skeleton argument. It's paragraph 54 of their skeleton argument, the bottom part, and it's just that Lady Justice Whipple in NC cited there found that where the obstacles are genuine but unfounded fear, particular care has to be taken to assess how that subjective fear will impede integration. The point I make is the one I made earlier, which is the first-tier tribunal rejected that there was a subjective fear.
Yeah.
So in my respectful submission, what the points my learned friend makes when boiled down just amount to a disagreement with the outcome of the Article 8 assessment. Finally, and thirdly, the point that we've gone through on the law, where a claim fails, medical claim fails under Article 3, it's rare to succeed under Article 8. And this isn't even the sort of case which is quoted in the dicta in MM, which was quoted in GS India, in the first quote of GS India, which I took your lordships and your ladyship to, namely the lack of availability of treatment twinned with lack of care. So where you've got treatment and then you're assessing the lack of care as part of a global assessment of the background factors, in addition to the lack of treatment, here it's simply lack of care. Here there's no lack of availability of treatment.
And on the findings of the FTT, there will be care as well.
Yeah.
Indeed.
Yeah.
And finally, just the point in my learned friend's skeleton argument at 91B about the USSD report wasn't raised orally, and therefore I simply rely on my response in the skeleton argument to it. So that's one response, and then the second out of two responses to their points in the skeleton argument about giving too much weight to immigration control, as your ladyship rightly pointed out, weight is a matter for the decision maker.
And also, Part 5A tells decision makers how much weight to immigration control.
Absolutely.
You're allowed to ignore it.
Indeed, my lady. And of course, their point that my learned friend's point that she came lawfully on a visit visa is somewhat undermined by the point that you took him to, your ladyship, about her not having the intention of leaving when she entered. Unless you wish me expressly to deal with the English language point, I don't think I need to.
No.
No, I'm most grateful. Would you like me to address, or perhaps I'll just very briefly address that LD case about your lordships and your ladyship really made the point that it's a relevant factor and simply goes into the balance. But just to be clear, LD was quite an extraordinary case. The reasoning by the first tier tribunal was also quite extraordinary. The context was this is an individual whose wife and 3 children had ILR. 2 of his children were minors. For what it's worth, it's paragraph 3 of that decision. And even the Secretary of State conceded that reasoning of the first tier tribunal couldn't stand. It was that bad. So this is entirely different when you're moving. So when you're moving from in this case from one set of adult children to another, the first tier tribunal, in my respectful submission, applied a context-sensitive approach, didn't negate any distress, or didn't say that would negate any distress, but just simply that found that was a factor, as she was entitled to do.
The tribunal weren't finding in LD that could never be relevant. They were just saying, on the facts of this case, that's bizarre.
Indeed.
Yeah.
So unless I can be of any further assistance, those are my submissions.
No, that's very efficiently done. Thank you both, Mr. Bowden-Ast. Mr. Jones, anything in response?
If I might just have a moment.
Yes, do.
It would be greatly relieved to hear that I have any 3 points, which I'll make very briefly.
Good.
One is
I
the point
don't mean good that you'll be brief, but I'm good that you're going to make some
I think it's good for all of us, Your Lordship. Just on the point of, my learned friend made reference to there not being, or him not identifying an indication within the medical evidence to reversibility of decline. You will actually find references to that in the supplementary bundle, page 116, paragraph 5.1.3, 119.
It's almost sadly common knowledge of us all that if you're in a position such as your client, it's one-way journey.
So I don't need to labour that point. I mean, it's based tragically on brain damage, and
Yes.
that's not reversible. On the subjective fear point, I acknowledge what my learned friend says the judge found, but the difficulty with that finding is straightforwardly that it doesn't engage with Dr. Heke's evidence about the appellant's actual presentation in response to the expression of fear, which is not a rational response, perhaps, but it is nonetheless real to her. And you have the reference from paragraph supplementary under page 147, paragraph 5.1.5, which I took you to, but I'd also commend to you the following passages from the first report, paragraphs 3.2 and 3.2.4 and 7, where what you see is other instances where the appellant is manifesting behaviours which are indicative of her being distressed by the fear of return, an actual physical response, including night terrors or bad dreams, shaking when she's being asked to consider the return to DRC. So it may well be that there is no objective risk, but it's difficult to see how the judge can conclude that the appellant doesn't have a subjective fear when she hasn't engaged with the evidence that she is actually describing physical reactions to the possibility of a return. And all of that really comes back to the fact that she, as Dr. Heke concluded at 5.1.5, she's not able to rationalise that fear. So I leave that there. And the final point, just on this materiality issue with regard to Article 8, the finding in Article 8 disposing of argument as to the absence of engagement with family support here as a factor bearing on the Article 3 assessment. The reality is that what the judge found in the first tier with regard to family support was alternative support was available. She still didn't engage with the impact of the loss of the existing support. She did find that the support from PE was not specialised, and she did find that the appellant survived instances where she was separated from PE and someone else was able to step in. But what is significant is that the other person that stepped in was another part of that committed effective care network, which was the other daughter. So another person with whom she had family life where there was a very close connection. So I think so everything we said about Article 3 actually plays through to the impacting on the Article 8 evaluation as well. Unless I can assist you any further, that's all I have to say.
Well, we're very grateful to you, Mr. Jones, and also Ms. Fitzsimmons behind you. I don't know whether your client or members of the family have been watching on the live link. They will at times have been struck by the legalistic way in which we've necessarily engaged with matters. None of the three of us, and I don't expect anyone sitting in this courtroom, is ignorant of the human beings at the middle of this and the sadness that surrounds your client's condition. And that was reflected by the grant of appeal by Lord Justice Phillips. We're aware of it. We have a responsibility to operate within what is a very strict legal system, and that's why we've approached it in the way we have. But I hope those watching have not misunderstood that for harshness or heartlessness. It's wrong if that's their impression. We'll reserve our judgments and circulate drafts in the usual way, encouraging you to spot the typographical errors, which will be undoubtedly there, but not to engage in any more significant further argument. It won't be necessary to attend on the hand down, which will be done electronically.
Thank you.
Thank you all very much.
And thank you for your time and tolerance. I'm grateful.
Court rise of able.
Drink.
You
Not a
deserve it
celebration.
after-
but thank you for emphasising the undesirability of dealing with that care.
Yes, for sure.
This is obviously not going to be the case for that.
No, I don't think I'll decide it.
Were they watching? Were they watching? Imagine how entertaining the day of watching me just getting barracked.
Yeah, I did mention to my family about hey, there's a live link. Although by the time the I started speaking, I think my parents,
You'd lost them,
mum,
had
dad,
you?
and stepmum will have already, I think, would be picking up my daughter from the childminder and be driving there. So
The only time my wife ever came to court to watch me, she burst out laughing when I put my wig on.
yeah.
And it was like the second time I'd been in the High Court, so I was absolutely mortified.
So you don't wear that at
I
home?
forbade her from ever coming again.
Fair enough. Yeah, I've no doubt that Anna would be quite similar.
Well done, by the way. First time
Too.
fee.
Thanks. Yeah.
Very effective.
Thanks. I thought I'd be more nervous. I used to
Probably
get.
exhausted.